Maricopa County. It's gone through lots of evolution and changes. Amy is the current expert. Ken's been a past expert of our particular program, so they're going to really give you the meat and potatoes of this. I feel like I can give you a lot of my perspective as a consumer of all the work that they did and the great work that they did. So we're really happy to help you in any way that we can.
Thank you. Ken?
Okay, I'll go next. I'm Ken Daly, Deputy Administrator in our Juvenile Department here in Maricopa County, as former Judge McNally, or Colleen, as she insists on me calling her nowadays, and I still trip up on that. We did a revitalization effort around 2016, 2017, and that's when I was, serving as mediator and supervisor of the program. So that gave me kind of a front row seat to system change and culture change and all the stakeholder work that supports this work and makes it sustainable. And now I'm serving as a deputy, so I've got more like an administrator's vantage. And so that's why we're so well complemented by Amy, who will talk next.
Well, thank you. So I'm Amy Stemke. I'm the Conciliation Services Supervisor. So I oversee a team of 10 conciliators, as well as a support staff. And I started as a conciliator in the juvenile department in 2016 and have been the supervisor in 2019. So similar to Ken, I saw it kind of at the start and have been a part of the evolution of it. And I love mediations. I love them so much. I've had some opportunities to talk with other jurisdictions, and we're really excited to help support you.
Well, thank you so much for that. Eli's going to be launching a poll. With a group this large, we wanted the presenters to introduce themselves. Others will be able to identify their role. And then as we move on through, if you're going to talk or ask a question and you're from Vermont, by all means, let us know who you are and what your role is as you speak. For anyone who does not know me, I am Susan Riley. I'm with Casey Family Programs. And my colleague Dan Despard had worked with this Arizona team setting up some of the original, and we've now, as we not often, but sometimes do, is wind up swapping around with the jurisdictions that we have the privilege of working with and serving. So really, really excited, and thank you. As you know, Vermont is focused really on quite a particular point in the mediation process to get started. But there's lots of new faces on here who've been learning from Brenda and Judge Grierson. And Eli is putting up the poll, so feel free to use it in the chat. Is probably your best way to do it.
And if it pops up and it's trying to get you to download something, just X out of it, and you can do it in the chat without having to download the app.
Perfect. So just ignore the swirling box in the middle. If you're seeing it, it will go away, and you can do it in the chat. So again, we really want to thank you and to give an overview. We only have an hour, so we will turn it over to you for about 10 minutes to talk some about your process, and then we'll go through some case examples and have some time for questions and things that I know you had an idea of the questions that they want to answered, and so therefore some of that I'm sure will be answered in your overview. So let me just turn it over to the Arizona team while folks are filling in the poll, and you can get a sense of who's in the room.
That's great. So I'll kind of start just as the practitioner of mediations. I always like to start with a little bit of information about our county because we have a very unique county. Maricopa County is geographically very large and population-wise very large. We have about 60% of the population of Arizona in Maricopa County. So we process a lot of petitions, we have a lot of cases, and geographically we have 3 different courthouses that we serve families out of. So typically, on an average month, our team is going to facilitate right around 100 mediations across the courthouses. So by volume, we do a lot. But I wanted to make sure that I sort of set the stage a bit with another really important event that we facilitate. It's something called a preliminary protective conference. The conference occurs around 5 to 7 days after a child is removed by the Department of Child Safety, which is our child service agency. In that meeting, we begin a lot of the conversation around safety planning. Safety planning is the idea of what needs to happen, what needs to change, what needs to occur to have the child return to the home with what's called a safety plan. So it's important to know that one of the reasons why we have successful mediations is because we set the stage early. In Maricopa County, most of us are fans of front loading a case. So if we can see parties more often, get those conversations started early on, that tends to have better results. So my team is tasked with just a couple of facilitated events, those initial conferences, and then mediations. I know we'll kind of get into some questions, but my program, we really consider our conciliators as what we call law-trained social workers. So most of us have a social work background, and that's one of the key differences with our program. And so several years ago, and I'll let Ken and I was going to say Judge McNally, Colleen had some additional information really about in 2016, our program really had a spotlight on us as an opportunity to address the mounting cases that our court was facing. And so mediation was really underutilized. And so we put quite a bit of work into sort of upping our game. And that's really what has made the difference. So I'll let Ken kind of fill in some of that background of how how that focus started and sort of how we've continued from there.
Okay, thank you. So yeah, when we started working and partnering with Casey to bring all stakeholders to the table and identify ways to reduce the number of children in state custody, at that time it was something like 17 to 19,000 kids in foster care in Arizona. And in Maricopa County, we had the lion's share of that. And so we were tasked with identifying underutilized resources for resolving these cases. And again, by the attorneys and the judges, they pointed to mediation as an underutilized tool. We had, as we were talking about at the beginning, we've had a mediation program in Maricopa since around '97, and that was championed by a champion of the process who happened to be an assistant attorney general staff member. He was a trained mediator. We got some success out of that, preventing upwards of 80% of trials that went through that process in the early days. That's certainly not a success measure we can brag about nowadays because of the volume again, and it's just kind of taken a different approach. We measure success a little differently nowadays, but it evolved to the point where people took their eye off the ball and it was not taken care of and cultivated. So that's why we needed to revitalize it in 2016 and 17. And we've learned from that experience and still use the important lessons that we learned, like regular stakeholder engagement across the system with our Department of Child Welfare, all of the attorney groups. Judicial leadership is critical. Just for perspective's sake, before I, transition away from this, we had in fiscal year 21, we had 3,100 petitions filed, dependency petitions filed, and at that time we had about 5,000 open. So this is, I mentioned that just for scale and perspective. Some folks or skeptics might say, jurisdiction this big, how can you do it? And we had to really add a significant number of conciliators. You heard Amy mention we have 10 members of our conciliation team, and I joined in 2013-14, we had 6. But we needed more because we needed to dedicate more time and resources. Time is a major resource that we needed to commit to the mediation process. And we can talk a little more about that as we start going through the questions. Colleen, did you have any additional perspective?
Thank you. And I would add that the judicial leadership was really important because although we had a court system putting resources towards mediation, without the judges making it super clear that this is an important event that people were expected to be prepared for, that the people participating had to have authority to settle cases, which was a big problem with our agency. Case managers would come in and just say, well, I can't, I won't, I can't, I don't know, or not show up. So we had to do a lot of things to underline the importance, including just tracking what was going on. We started tracking like whether people were showing up, whether they were showing up on time, and letting and being very transparent to the parties and the lawyers about we care about this. That's why we're tracking it. And we're going to let you know what your data looks like, what your attorneys are doing and not doing. And that really sort of transformed, I thought, the significance that started being placed on the mediation, and also underlining the opportunity it was giving everyone to actually avoid what's often a painful process to go through a trial. I don't know. Those are some of the things I think you need to be thinking about from the outset. Is how do you help each party that's going to participate in the mediation understand the benefit to them? Because to all professionals, there's a benefit in not having to devote as much time later on. But absolutely for case managers and for families, there's a benefit to a resolution that they have a hand in creating. And I felt like Ken and his team at the time were just so good about helping us to convey that message that this is really for you. It's for you to design the decision that we're going to come to, instead of someone who, as much as they might care, as much as Judge McNally might care about your family, I mean, she doesn't love your kids. You do. Let's figure out what your kids need.
That's great, thank you. And I think it was beginning to address some of the questions and concerns about how did you get buy-in, and helping people to understand what's in it for me. So the next question, really from Arizona, after that real kind of high-level background overview, was if you could share maybe a couple of examples of cases and kind of a deeper dive into what made that work, or where were there some challenges? What was a lesson that you said, aha, okay, now going forward, we've learned something that we're going to continue to learn from and tweak. So take it away.
I'll tackle this one, guys. So one of the, kind of speaking to what Ken and Colleen mentioned, we're really big believers in conciliation services in procedural justice. And we see our facilitated events as having a key role in a family's procedural justice. Families who feel heard, who understand the process, who see the transparency. And so that is sort of an undercurrent of our mediations. And so, Ken mentioned that we sort of capture success in a different way. And so we really see mediation as an opportunity to move the case forward. In doing so, you likely are resolving legal issues, because a parent who feels heard and supported may be less likely to want to go to trial, because maybe they are upset about their parenting time. And if we can help settle that, that moves that case forward and they're not stuck on that. And so a lot of what we do is helping parties identify what are the barriers to moving this case forward, whether it's parent engagement, maybe it's referrals, maybe it's the parent doesn't have a phone, so no one can get a hold of them, some of those basic things as well. And so I'd like to share a couple of examples with you of some mediations that I've had recently. I don't do a ton anymore, but because I love them, I can't help but do it. And so, I think it's important to know that one of the biggest things that we did, and Colleen mentioned this, is we set the expectations for parties, because especially our attorneys and our social workers got sort of complacent and just didn't add much value. And so when we started to expand those expectations, the attorneys and social workers, they delivered. And it's really a night and day difference from when I first started with mediations. And so the first example I'd like to share is the benefit of sort of in the moment problem solving and how it can positively impact court time and to a lesser extent case management. So I had a mediation in which the child was placed in the home with her parents, and she was a medically complex or medically fragile child. And so she had a lot of doctor's appointments. And so as we start the mediation, the Assistant Attorney General states that they are filing a motion to remove the child from the parent's care and place the child in foster care because the parents violated the safety plan. Safety plan is just as it sounds. It's the plan that everyone agrees to keep that child safely in the home. And so the doctor's office had reported to the social worker that the parents had attended the last visit without what we call a responsible adult. It used to be called a safety monitor. It's really a supervisor for the parents. And so because of that, the department was filing their motion and wanted positions. And of course, the parent and their counsel said, well, that's not true. That didn't happen. I don't know what you're talking about. To save you more of the story, in that moment, the social worker was able to call the doctor's office, who confirmed who was at the appointment. And it was the mother and her father who was the responsible adult or the safety monitor. So the department was working off of the wrong information. And because we were able to problem solve in that moment, right, we had this amount of time where that social worker said, sure, I will call their doctor's office to get more information on it. And that was kind of an awkward mediation because the department had to come back and say, oh, sorry, guys. And so I think of that as an example, and the child was able to stay in the home, and the case has actually since been dismissed, which is nice. But that's an example of mediation being used as I sometimes tell parties, let's get on the same page. Let's share the same information so everybody knows what's going on. So had we not had that mediation, that motion may have been signed by the judge and moving the child, or it could have been set for a hearing, and that's taking up valuable court time, which would have brought more people in and probably taken an entire afternoon of a judge's calendar. So within a short amount of time, we were able to problem solve. But the other, and this is one of those sort of harder to measure successes, is that parent felt sort of vindicated that someone listened to her, that she was saying, that's not true. And the department had to say, you're right, we're sorry. And so that actually helped sometimes heal that really contentious relationship between the parent and the social worker. So that was an example of really just asking questions and just being mindful of when to sort of push folks a little bit and not just say, okay, parents council, what's your position, and kind of move on from there. So I was happy with that result. And really, again, that was just through problem solving and sort of a happy ending, sort of in the end. The other example I'd like to share with you is a bit more about what we call safety planning. Again, that's the idea of having robust conversations about what we call in our state conditions for return, which are just as they sound, right? What needs to happen for these kids to be home with a plan. And so I had a mediation in which the father was really angry at the Department of Child Safety. And I sometimes tell parents it's okay to be angry, right? It's what you do with that sort of anger towards the department. And so the department didn't really like this dad because of his anger. And it wasn't geared towards anyone. He was just kind of difficult to be around. And so we get in this mediation because father's attorney had filed a motion to return the child. She was in foster care, and to return her to her father's care. And so that was really the primary focus of our conversation. And so in talking with the department, and you all may experience this in your own court, sometimes the state will say, well, we have concerns, and that's why we're not ready to move this child. And you say, well, what are the concerns? And they say, we just have some concerns. And so for me, that's a clue to dig a little bit deeper, because what are they? Because if the parent and the attorneys don't know what the concerns are, how are they going to be able to change it to have their child home? So a lot of this mediation was really encouraging the department to articulate what is the safety concern? What is the real issue here? And it turned out that the department was uncomfortable because father had a medical marijuana card. Around that same time, Arizona legalized recreational marijuana. So we've had some conflict with that, but that's kind of an important piece, that not only did he have his medical card, but also in Arizona, it had been legalized. And so we had a conversation about, well, what are the expectations of father and his medical marijuana and its storage, because it was a toddler. His daughter was a toddler. And so the department really had to articulate more than just we have concerns. It was really, well, we're frustrated that father doesn't communicate with us and that he has a medical marijuana card and he hasn't really, it feels like he hasn't really talked to us about it, and a lot of these sort of intangible concerns. And so when it got down to it, the tangible concern was storage of the medical marijuana. Everyone agreed to how father was going to store it. The department came out and did an inspection to make sure that, he had followed that. And then the next day, the child was returned to his care. And so that father was still really mad at the end of the mediation because he had expected his daughter to be returned to him, that day. But by the end of it, it took a week, right? But the process worked. And I think without that mediation, the attorney told me afterward, without that mediation, they would have had to go to court. They would have had to present this and likely would have had the same outcome. But again, we're saving that court time, that attorney time. But ultimately, we're helping these kids. And so I always joke that, of course, as a mediator, I'm neutral. I joke that I hold everybody accountable. Everybody in my room, I'm going to hold you accountable. But at the end of the day, we really are there in the best interest of that child, just like we all are in that room. And so a lot of times that's our motivation for pushing some of those conversations. So I joked with Ken earlier, I have a million examples. So if you ever are like, hey, have you ever had a mediation where X, Y, and Z happened? I probably have. I tried to calculate once how many mediations I've done, but it's a lot. So I've had massive failures in mediations, and I've had ones where almost everyone is crying at the end because we've solved the problem. So those were some I wanted to share with you that I think are indicative of some of the work that we do in our mediation. So with that, I'll turn it over to somebody else because I will talk all day about mediation. So.
Well, that's great, because not only did you, I think, answer some of the questions and wonderings and worries that some of the folks in Vermont had, but I also really appreciate people are asking questions in the chat, and our Arizona consultants are actually answering them in real time. And the theme that I'm sort of hearing so far is help people understand the benefits to them as well as to the child, set the expectations really clearly around things like time, and that this is not a nice frill we're doing on the side. This is actually a part of the process at whatever point Vermont has chosen a specific time to start with. And that those kinds of things in combination, understanding that, yeah, we may have to stop here, and in this moment, we're taking a half an hour that we wouldn't have done in the past, but it just probably saved you 2 more court visits. So that's what I'm hearing so far, and I'm seeing nods from Arizona. So yes. Does anyone else, Judge/Colleen or Ken, want to, again, share another example that's kind of answering some of the questions that you've seen, or we can go to questions, whichever way you prefer.
I wanted to highlight a couple things that are in the questions that you all had, and that is that it's really important to get high quality mediators. Amy and Ken both talked about the kind of qualifications of having knowledge about, be knowledgeable child welfare advocates or, people, and also understanding the legal system, and also having a current connection to your collaborative community of attorneys, social workers, court staff, because you have to keep evolving. I mean, I'm hoping it's still evolving since I'm no longer a part of it, but it's really, really important for it to have legitimacy, to have people that are understanding the possible solutions that aren't quite apparent because of their experience in other realms. And one of the things that came up in when we were doing our revamp was judges were, we were kind of doing an automatic setting of a mediation. Like if we were going to schedule a trial, then, well, you're going to get a mediation next. And it turned out the judges were kind of jumping the gun because we were scheduling before the attorneys had completed discovery. So they're showing up with not, as Amy said, not having all the information they needed to settle a case. So it's really important to be have active community stakeholder conversations about, you know, how you're going to set it up and also how you're going to keep improving it, because it's got to have that continuous quality improvement aspect to it.
Yeah, I'll piggyback off that. That I think is one of the keys, is the stakeholder involvement. Because if we had just created a mediation program and said, here's what you're going to do, that would be just a failure. And so even still, we have, I host a mediation best practices work group quarterly. And it's really an opportunity, again, for those stakeholders. Let's talk about what's going well, what's not, what do we need to change? Because and one of the biggest questions we continue to ask is, what do you hope to get out of a mediation? And are we crafting it so that our stakeholders still find benefit to it? And we have. But that, I think, has been key, is that collaboration.
Yeah, you know, mediation isn't something that's happening to the parties. You know, there's self-determination involved by everybody. Very importantly, you know, the parents involved in the case, the youth involved in the case. And that's a principle that we really try to highlight and apply, you know, liberally. And that's where, you know, the collaboration, the candid conversations that need to occur to get people to rethink their assumptions about what they prioritize during their court day, the work day, checking with the parents about, you know, times that actually will work for their work schedule. I mean, things like that just weren't being considered because our system wasn't recognizing autonomy and the importance of autonomy. Autonomy isn't granted, it should be acknowledged or recognized, but that's enough said.
I'm wondering, one of the questions that's on here, and it's always hard, those of us that move back and forth across the country and in different jurisdictions know that if you've seen one child welfare system, you've seen one child welfare system, and I'm sure the same is true on the judicial side. So it's kind of hard to compare apples and oranges sometimes. But I do think it's kind of a valid question if you could describe a little bit. I'm certain that they're probably different in different roles, but and I'm going to ask somebody from Vermont who's in the legal system to perhaps, you know, explain a little bit more about the difference in the roles that you have and how those might be similar or different than Vermont, just so you can be sort of aware of that difference and think about how it might be done a little bit differently in Vermont. So I don't know whether that's Evan or Judge or Marshall or Brenda or who. Or maybe I could say, who asked that question? And then maybe they want to speak up a little bit.
Let's share the question.
And this was the question about, can you please speak a bit about the participants? Vermont has a model where state's attorneys and assistant attorney generals are responsible at different points in the case. Is there something similar to that in Arizona? And what about the role of a guardian ad litem?
I can tell you, we don't have that system. We have the same attorney general, although they have a lot of turnover in their office. But one of the problems we did encounter was that our child welfare agency had a system where they were always changing case managers right about when mediation was supposed to happen. So you were not having continuity of expectations, of communication. There were a lot of problems like that. So I imagine you might share that. You know, that might sort of be a correlation there. We do have guardian ad litem attorneys in Arizona, and they are appointed in every case where and it's sort of opposite of the ABA model. We don't appoint attorneys; we appoint guardian ad litems in our county. I think they're still doing it that way. Who have they have a voice just like any other party in the mediation to you know, object or to be a part of the solution.
And I'll share, I think, you know, in a typical mediation, in about 99% of mediations, you're going to have The assistant attorney general, the current case manager, sometimes you'll have the previous case manager, sort of depends on when it is in the case. We have the parent. We typically advocate for bifurcated mediations because 60 minutes is generally not enough time to talk to both parents, but we defer to attorneys for that. And then if with the youth being present, that's something we're actually trying to increase because we typically, for whatever reason, have not. We have low attendance of youth, and then we have the guardian ad litem and the child's attorney if they're there. Sometimes, if it's appropriate, we'll have placement. Depends on if parties are in agreement with that. That kind of is hit or miss, but at the very least, we're going to have parties and their attorneys. And so, I'll say as a practitioner, GALs are historically not the holders of information. It's typically mostly a discussion between the Assistant Attorney General and the Department of Child Safety and the Parents' Council. But one of the nice things about mediations that I always tell folks is we encourage parents to speak up because it is a confidential matter. And it's really one of those opportunities for that client, that parent, to have their voice heard in sort of that non-adversarial setting. One of the questions I just saw pop up that I'll help answer. No, in our court, no one files like a formal memorandum of points or anything like that. However, Colleen talked a bit about the importance of that, of the judicial support. And so one of the things that we do have in every minute entry that sets a mediation, there is language that is ordering parties to engage in prior communication. Essentially, the Parents' Council needs to email and say what they need to talk about, and the Assistant Attorney General has to respond. And that is, they are ordered to do so. Now, I'll tell you that doesn't mean that it happens all the time, but that was one of the keys to our evolution, was really requiring this prior communication, because that's, that does allow, especially the department, to staff, certain concerns and make sure that right decision maker was there. And we've seen a huge increase in the correct decision makers being in the mediation. And a lot of that came through, if it was not if it was just a warm body, kind of case manager there, we would ask if parties wanted to reset, and they almost always did, because what are we going to do, right? So that sort of forced that behavior change, that it needs to be the right people there. And so most mediations last about an hour. And because of the number of conciliators we have and the way we schedule it, I tell folks a mediation is going to last as long as it needs to last. Once you get into that 90-minute mark, folks start to kind of trail off. But we do, I think Ken mentioned it, we do offer on-demand mediations, because one of the unique things about our mediation calendar is that we control it. It's not controlled by a judge or a clerk, it's ours. And so we can set and reset mediations without judicial approval. And so if everyone is in agreement, we schedule a mediation. And so if we host one and they maybe some things need to happen and they need another mediation, well, we're going to set it. It's really what's more important is when it is set. That 45 to 60 days, 60 to 75 day mark is pretty crucial for our mediation. So I hope that helps sort of frame kind of the expectations and roles of our mediation participants.
That's helpful. And Judge Grierson, you look like you might have been wanting to get in. But one of the things I heard there, Amy, that sounded really important is, let's agree ahead of time what we think the core issue is we want to talk about. Doesn't mean that maybe other things don't come up in the course of that. But instead of everybody coming together and saying, what did we want to talk about? Oh, if we'd known that, we would have brought this person. Let's do it ahead of time. So that I thought was really key. Judge Grierson, am I correct? Were you trying to get in?
Part of the puzzled look, Susan, is attributable to the fact I was having trouble with the computer and the internet. So putting that aside, though, so I may have missed some of the comments. I first want to say hello to Colleen. It's been a while since we met when Colleen was still on the bench, and I'm about to join you in the retired portion of the seating. So I just wanted to say hello. And if I missed this, please tell me I missed it, and the others will pick up on it. And that is, I heard that you appoint guardians, but they're actually attorneys for the children. So the children don't have attorneys per se, they have guardians who are attorneys. Yes?
You know, Your Honor, that we've just had some recent legislation passed by Generation Justice, Colleen, and that's reversed that practice. It requires attorneys be appointed for each dependency case, and that's primarily to address the languishing in foster care. They feel the intent behind that legislation was to well, the presumption was that an attorney is going to advocate for the more timely return to families or permanency, and that's not something that, according to the legislation rationale, that GALs were capable of doing, perhaps because not all GALs were required to be attorneys in our state.
Okay.
That's just not the case.
So at least going forward, children will have attorneys and the parents will have attorneys.
Yes.
And then do you envision the attorneys, both attorneys, being part of the mediation process?
Yeah, absolutely. Whether our mediators like it or not.
Okay. Because I think that might have been an issue in a previous attempt in Vermont to have mediation. The other question I have is, obviously we're just starting, and we certainly understand the need to get a qualified individual in the role of mediator, and this is essentially going to be a pilot, so we want to be very important in who we first employ. But in starting out, do you have recommendations? We're thinking of staying away from the tail end of the process. In other words, not looking at necessarily mediating termination of parental rights cases, but focusing on the beginnings of the cases after a temporary care hearing, and probably before merits. And that's the direction we're heading. Would you recommend that as a place to start?
All three of us nodding our heads.
Absolutely, yes.
Yeah.
Okay.
And I would say that we had at one point the judges were practice was that we were appointing we were ordering a mediation whenever we were scheduling a trial of any kind, like scheduling a termination trial, and we recognized that was not a good use of the resource. So really the only time we began scheduling mediations for a termination would be when the parties specifically requested it, and often that's because they knew that there were issues that might obviate the need for a trial that really weren't maybe legal issues. Often it was contact agreements and things that were outside of that. But I don't think it's a great use of the resource as a mandatory.
Yeah, I would agree with that. Our mediation sort of post that severance filing really most of the time have to do with if the termination is granted, this child is adopted, what will communication look like? Rarely is the issue of termination really resolved in the mediation. And one of the, I mentioned our law-trained social workers, and by law-trained, we do have some dual JD and MSW holders on our team, but it's really more understanding the dependency process. So from removal to reunification or adoption, do you understand what those hearings are? And so in our court, and I just hired a couple of new conciliators, I value child welfare experience. I really value that above much else. One of the other really helpful documents to take a look at is the Association of Family and Conciliation Courts, AFCC, has some child mediator core competencies, and it really goes into what should a child welfare mediator possess. Because a mediator who works, let's say, in family court, resolving custody issues, divorce, that kind of thing, it is not the same as the work in child welfare. It's definitely kind of a niche role, the child welfare mediator. And so that's something that our court values. And it just so happens that A lot of times we do have law trained, like with JDs who also join our team, but most of our team are MSWs or have 10 to 15 years of that child welfare experience. That has made the difference. And I think some of that speaks to the procedural justice that if we sort of know as child welfare professionals how the system is supposed to work, we can identify when it's not working and help parties resolve those issues. So that's one of the reasons why our court has really adopted more the social work heavy model.
And then just very, very quickly, there's a good journal article. I can't remember all of the authors, but Dr. Alicia Summers, I think it was conducted through National Center for State Courts, that really did study and make some findings around the front end. This is my point. Front loading cases with problem solving avenues has a good positive impact on reunification rates with family and kinship, and time to permanency. So if that's a resource that would be helpful to you, I'd be more than happy to forward that information to the team.
So I think that gets to the couple of the other questions that were on here. One was about, have you seen an impact on TPRs, which you just addressed, which is yes, if we get in there early and engage and get in conversations, the likelihood of reunification in a timely way is higher. And likewise, we talked a little bit earlier about CQI processes and measuring success. So I heard some of the things you're measuring. Are people getting there? Are they getting there on time? Are they, doing what they're supposed to do in order to? But what other kind of data are you tracking? Are you tracking things like the number of reunifications in a timely manner, or what are some of the things that you're actually tracking?
So I'll start just on sort of a basic level of what we track. A lot of it is party behavior. So did you engage in prior communication? Was disclosure complete? Because lack of disclosure is rampant and is the number one reason why a mediation isn't successful, is because of lack of disclosure. So we keep a lot of that information really for attorney leadership so they can keep tabs on how their line staff is practicing. But we also measure things like what was discussed and were there resolutions made or agreements made based on sort of our top 10 things that we talk about in mediation. So one of the things, and I know Ken will mention this, because we measure success of mediations in a different way, and because it's hard to quantify, we try to focus on what we can. And so we have higher rates of agreement for things like parent services, meaning everyone's in agreement that parents going to engage in this. We have more rates of agreement for conditions for return. Again, everyone hearing and being on the same page about that. We also have a high success rate in preventing a case plan change from reunification to severance or adoption in our court. And so one of the things that's difficult in our data practices is it's hard to tie a mediation to expedited permanency. It's hard to connect the two because it's hard to say that the mediation was the reason why reunification sort of happened early on. And so that's something that we're continually trying to evolve, is having better data practices. And so a lot of what we do is behavior based, so we can adjust maybe what we're focusing on, especially in that work group. So, and we keep data, total number of mediations, rates of agreement, how long they lasted, when was it scheduled, was there a follow-up scheduled, some of those things. So I can share that piece at least.
Great. So a lot of those are sort of process kind of measures to make sure that the process is moving along smoothly. Then you can sort of, and again, I know well that there's causal and there's related, and that you can't necessarily draw a straight line from here to there, but probably over time you can see themes that say when there was full disclosure ahead of time, most of those wound up coming out in what we would define as success, in that the child was reunified or there was an agreement made or whatever it was. And the same probably with things like TPR. It's not going to be causal, but do you see themes over time if you collect the data long enough? Very interesting. There's another question that's very, very concrete, but I think it came up a couple of times, both in discussions and in collecting, which is, do you have dedicated space at the courthouse? Is that where folks are meeting, or did you need to find other space?
So Ken and I were talking about this yesterday, that, one of the benefits of having child welfare professionals and social workers in this role is that we have a really kind of a higher rate of being trauma informed or trauma sensitive. And so because of that, we are very mindful of where we host our mediations. And so in our courthouses, mediations are in conference rooms, but they are conference rooms that are also the offices of the conciliator. And so they are away from the courtrooms. They are on different floors. They are, they still have to go through security and that kind of thing. And so one of the nice things, and I'll invite Ken to add to this too, is we've been offering virtual mediation since March of last year. And so one of the cool things about that is talk about leveling the playing field, right? Because literally everyone is in the same size box as long as they turn on their camera for the event. And so we who may be still in their addiction, who may still be struggling, it's easier for them to appear virtually than in the courthouse. But physically in our courthouses, we do utilize conference rooms, but we make sure that they are as sort of inviting as possible. So that was not a difficulty for our program.
And I will tell you, from having worked in numerous jurisdictions in trying to set up things that look somewhat like mediation, different kinds of family meetings that are decision-making meetings about removal and those kinds of things. We literally say how you set up your room is important, and where people sit around the table. And do you have a box of Kleenex in the room? Not sort of often the typical way that case reviews that involve parents are done, but can we make this a little more family friendly and feels like we're really here to talk to you and value your opinion, not to show our authority. So that's great.
Yeah, that's right. Just
go ahead.
Set and setting, little pipe cleaners, fidget toys to acknowledge that it's a nerve-wracking experience, pictures on the walls and little things, even though we don't practice what I'm preaching right now, I think a round table versus a long table, is a good, if you're in the business or have the opportunity to choose your furniture, consider a big round table, because it just gives that psychological even playing field, the same way Amy was discussing the virtues of a remote setting. Everybody's the same size on camera, so long as everybody can, get on camera, on video to participate. And by the way, we are going to be carrying forward remote access to these problem-solving events post-pandemic. This FYI.
So there's a couple of questions that have come in the chat in terms of your mediators. Are they employees of the judiciary, or are any of them private practice that get brought in?
Yes, that's a good question. They are court staff. As Colleen was mentioning, we had to remind people these are court sanctioned events, just because they don't happen in front of a judge or in a courtroom doesn't mean they're any less priority. And we got that funded originally from court improvement dollars. So, and we still to this day have, one of our 10 positions now funded with that, annual court improvement grant.
And this other question that Chris just asked, I can see that being a good data point to track over time about do you see any trends in the economic level of families who have participated or are willing to participate, and the impact of addiction on outcomes? Do you see any differences in that?
I think in our jurisdiction, like in a lot, most of the families involved with the Department of Child Safety fall into a low economic class. And so Ken and I and Colleen, as a retired judge, are doing some work in especially racial and economic disparity of kids who have entered care. And so we do keep, and the Department of Child Safety keeps track of removal zip codes. And in the Phoenix area, you can see that most removals happen from low income areas. So unfortunately, most families involved with the department are low income. And so one of the specialized positions I have on my team is called a resource coordinator. And that's another trained person who can work directly with the parent to connect them to area resources. So if it's housing, a food box, a cell phone, and that person can help them in the moment. So that's one way we sort of tackle that. A lot of our cases have to do with drug addiction. In our jurisdiction, neglect makes up the majority of our cases, and most of that neglect is drug abuse.
Something like 80%.
Yeah, it's most of them, most of the cases coming in. And in Maricopa County, we still have really meth as our number one, with other opiates like other jurisdictions are facing. But in our county, meth is still really, unfortunately, the drug we see most often. And so one of the benefits of our facilitated events is that we can help connect parents to some of our programs who may help them. One of the wonderful programs that we have, shout out to Judge McNally, it's called Family Treatment Court. And that's really a dedicated court to support parents in their recovery process. And so although that is sort of a separate program, we get to be that warm handoff, that it's not just here's a phone number you can call. But back when we were in the courthouse, I literally could walk that parent over to our treatment court coordinator and say, hey, this parent is interested. Could you talk to them about it? That makes a world of difference. And so we have some other specialized programs in our court, specifically for families battling substance abuse. So we try to be pretty mindful of that. And I would say most of our mediations are involving families who are still struggling with addiction, especially if it's sort of in that 60-day mark, that parent may be still working towards sobriety. So hope that helps.
Just one additional thought on Chris's question. There's how we do it in ours. There's opportunity to get to the answer by tracking the allegations at the beginning of the case. And, then what I'm saying is we have case management software that is our tool to get to those answers. So if there's, case management software and there's the functionality to add that, it's a good idea to start with things that don't prevent you from measuring such things in the future. Or you could get that elsewhere, perhaps, if the department is tracking that kind of thing, but that takes, good, constant, persistent, collegial conversation between systems.
I'm going to jump in and answer a couple questions that came up because I know we're getting close on time. Parties do not pay for mediation. It's part of what the court offers as a conflict resolution. I would say we got a lot better at listening to attorneys who and respecting them as experts on what the legal issues are in the case and whether things are ripe for mediation or not. And for instance, when there are criminal charges pending, sometimes attorney will say, Judge, it's just not going to be fruitful. We're going to waste everybody's time. And we started listening to that instead of saying, go to mediation anyway, because we make everybody do it. So I think it's really important to try to get all our resources on board to figure out what's best and to listen to each other.
Well, thank you.
I would say that I'm sorry. I would say in most cases where there are pending criminal charges, we won't host a mediation. Exceptions are sometimes if sometimes in a mediation, you'll have the criminal attorney plus their dependency attorney, and we'll do that. But oftentimes we won't, and like Colleen said, we'll really defer to the attorneys, and most of the time we don't when it's especially child abuse related. If it's drug charges or possession, that kind of thing, we can. But with child abuse criminal charges, those are a little too sticky for us to engage in mediation usually.
So Eli, I know we're coming right up to the top of the hour. Did you want to? And I think the questions and the conversation could go on all day, and I suspect that the Arizona team would be really willing to engage in another conversation or emails or something. So I think we can keep that going, but I want to turn it back over to you for any next steps, since you're the one who's herding all the cats here as we move along.
Oh, I'll go ahead. So yes, if I believe that there are still some questions that we haven't gotten to, and it seems like there are some more questions that people are thinking of as we're having this discussion. So I'm wondering if it would be possible to have like follow-up conversations, and I can be in touch with you, Arizona folks. That'd be excellent. Thank you. And I just really wanted to thank you for coming and sharing this huge wealth of knowledge and experience that you have built up. We are in absolute admiration of your model, and just so excited and honored to be able to take on this project for ourselves, and hope to see the same successes and the same passion and the same overall good for the children that you have been able to achieve.
Thank you all so much. So between
Thank you.
Eli and myself, we'll figure out any follow-up TA and what format that should take. And thank you all. Greatly appreciate your time.
Thank you.
Thank you, Arizona.
Thank you. Thank you. Go get them.
Good luck.